everyone, I think, except
Never a holiday in
such,
Magistrate Court.
right? That is true, and so that is no further truer than for Judge Motley Broom, Judge Osby, and Judge Hughes, who will be working all this weekend, handling all those shifts, and so I'm incredibly thankful for you all. I also want to acknowledge in the room, we have the Chief Magistrate Judge from Gwinnett who is here, Christina Bloom.
Thanks for
We
letting me
also
know.
have visiting judges with us. We have Judge Philip Jackson from the Fulton County Juvenile Court who is here with us. Judge Roberta Cooper, who is with the City of Atlanta Municipal Court, who is also with us. And so this training was opened to any of the judges in the metro area. It is being recorded through an AOC, Administrative Office of the Courts, so that we can have the pleasure of hearing from Judge Burke. Kevin Burke is a trial judge in Hennepin County, Minnesota. He's a past president of the American Judges Association and is one of the most recognized leaders within the American judiciary. We are incredibly pleased to have Judge Burke here. He flew in this morning and will be flying out shortly this afternoon, immediately after this presentation. So really came in specifically for this training. As many of you all know, this training is a part of our High Volume Court Simplified project. It was the grant that we received back in March of 2017, and so that is continuing until we finish, I believe, October 2018. So we were kind of crushed to get Judge Burke here to present today. Judge Burke was elected to 4 terms as Chief Judge and 3 terms as Assistant Chief Judge, and during this time he instituted social science studies, and reforms, including improving procedural fairness. Judge Burke has been named one of the 100 most influential lawyers in the history of Minnesota by Law and Politics magazine. He also teaches at the University of Minnesota and the University of St. Thomas Law Schools. He's been a speaker in 38 states and countries such as Abu Dhabi, Canada, China, Egypt, India, Ireland, Mexico, and it says Ireland twice. I'm not really sure why. I apologize. Regarding improvements in judicial and court leadership. Thank you all. If you all would help me in welcoming Judge Burke. Thank
you. Okay, so here's the deal. Now I'm going to switch to how we make decisions. How we make decisions in high volume courts is really pretty important to figure out how to deal with, okay? A lot of what we do is reflexive. It's automatic, it's rapid, it's unconscious, and the bottom line is the only way you can get through life is to be able to make a lot of decisions like that. And clearly that's a big part about being a judge in a trial court level where you got a lot of stuff going on. The other is reflective, it's deliberate, slow, and it's conscious. It requires attention. Okay, so if you see a stop sign, you don't read stop, you see this thing and you make a decision, you get going. So what we want to try to do is to get a little bit better understanding of that decision-making stuff. Oops. Okay, next. There's a limited capacity that we have for making stuff. Okay? So most of the time we solve problems without close, conscious, step-by-step analysis. That's true about being judges. Next. But schemas cause problems. Okay? So we got to think about what they are. They can be based on inaccurate information. They can be partially correct, stereotypes, and they can be applied incorrectly, assuming a gesture used by one culture means the same thing to another group. Next. So we got to be thinking about implicit biases. There's a lot more discussion now among the judiciary about implicit biases. Have any of you taken the Harvard implicit bias test? Okay, so you can go online and take the Harvard implicit bias test. It's pretty interesting stuff. It'll tell you something about yourself. You don't have to share it with anybody. I'll tell you one story, though, about there's a federal judge in Iowa by the name of Michael Bennett. Bennett and I have co-authored a book with a bunch of other people. And you have to understand who he is and who his background is. He was adopted. by a African-American couple. He's white. So his parents, from birth, were black and he's white. He went to law school and was a civil rights attorney until he got appointed to the federal bench. He took the implicit bias test, and what came out is that he had some issues, his word, not mine, with African Americans. So he was insulted by the whole thing. And if you knew Mark Bennett, go look up about him, his reaction was predictable. He set out to show the whole thing was hocus pocus. And then he had to come to the conclusion is it wasn't. He really had some things that he had to be more careful of. Okay, next. So this is what can happen, and we've got to think about this in high volume courts. Number one, you rely on small samples. Okay? And this is what will happen. I have a very high volume calendar, and I'm going to set bail in those cases. Right? Got a lot of cases I got to go through, but let's go. So what happens is you take the first case and you do whatever you do. You let the guy go, you set bail, doesn't make any difference what it is. Come to case number 2. If you're not careful, what will drive the decision is comparing number 2 to number 1 because we want to be consistent. And that's the problem. It becomes small sampling. Okay. So now I do 1, 2, and 3, and I'm comparing 2 to 3. I got to be careful about small sampling. So you say, how do I overcome the pitfalls of small sampling in high volume things? And the answer is pretty simple. You occasionally ask yourself that question mentally. Am I doing this because I'm doing small sampling? And it tends to ameliorate it. A lot of studies that would show that's the way to deal with that. Framing is, you know what this case is all about. Okay? So what we know is this. In medicine, the major cause of medical malpractice is a premature diagnosis that leads to the doctor driving right by symptoms that would undermine what that was. Okay? So for a judge, it's the same thing. I got to be careful about framing that I made a premature diagnosis about what this case is, and then I got a problem. I'll give you an example in which I absolutely did it. I have a case. It's a woman who claims that she was a victim of domestic abuse, who moved from the state of Washington to Minnesota where her mom lived. The dad litigated all the way up to the Washington Supreme Court that he had a right to have a child custody determination made in the state of Washington. And the Supreme Court said, no, you have to go to Minnesota. I have nothing to do with the case up till now. So she files an action in Minnesota to give her a complete custody of the child. He shows up and he's complaining about that he shouldn't have to come here. And he looks like a hippie out of 1968. I mean, he's like, wow, character. I know what he's all about. And I try to explain to him, look, I can't send you back to Washington. And they won't take you. Even if I agreed with you, they won't take you. So we have a trial. She's got a lawyer. He's self-represented. She comes across pretty good, and her lawyer's quite good. She comes across, she said early on in her testimony, she's quite surprised that he's here. She thought he was really a sperm donor, that he wasn't ever interested in the kid. He has not seen this girl, who was at the time 8, since she was 5. His cross-examination, I get myself all ready because I'm going to have to, step on him because he's going to do something weird and stuff. He's absolutely not weird. That is, he's respectful to her. He asks questions about her pregnancy that were totally appropriate. They were leading. Isn't it true, I went to the doctor with you during the pregnancy, and I went and we learned, and then he knew details of her pregnancy, which was somewhat complicated, that you were interested in this birth. So then what comes out is this trial that I think I'm going to be done with in an hour is now 3 o'clock. And what I've now learned is his belief is he did not commit any domestic abuse. He has a nice place for the kid to live. It's on a walnut farm, and it's really nice. She describes the walnut farm as filthy with no locks. You couldn't let a kid stay there for a few hours, let alone for any length of time. So he hasn't seen the kid in 3 years. He really is, this is all because of her mom. It's not about her, it's the mom who would have to testify. Two in this case. So I come out and say, you haven't seen her for 3 years. How long are you going to stay here? She says, I can only stay for a couple more days. So I said, I'm a little bit like a fireman. I need to come and put out the fire, and then I have to figure out why it started. You don't want reflective firemen. They come up to your house, it's burning, and they say, oh, that's a fire. I wonder how it started. I wonder how we should approach this. I mean, you want them in there throwing water at them. So I call a guardian ad litem and say, tomorrow morning I want you to do a supervised visit between the little girl and the dad, so at least you can see her in a safe environment. Mom does not like that idea, but too bad her lawyer gets her to do it. So the guardian then makes a report that next afternoon and says, we met at the Mall of America, and there's kids stuff there, and the little girl was walking along with the mom, and when she saw the dad, which she described as at maybe 100 yards, she broke from the mother and started running directly to her dad and grabbed him, and she was so happy to see him. The guardian said there's no conceivable way that dad, who hadn't seen this 8-year-old in 3 years, did not have some decent relationship with this kid. So fast forward, I'll now tell you the end of the story. Grandma left Minnesota. She hates my guts. She moved to Florida. Mom moved back to Washington and has shared custody with the little girl. They're not together as a couple, but they're effective co-parents living on the thing. The one other fact I didn't leave is, so now I have no idea what the hell's going on in Washington. So I called a judge who I know. The nice thing about traveling is you know judges all around, so I might hit you guys up someday. So I called this judge in King County and said, can you get a guardian ad litem or somebody who would have to have skills to go out and inspect the walnut farm? And so she said she found this woman who was the head of child protection who just retired and said she'd do it for nothing, go out there and do it for me. So she gives a report and she says, this is a perfectly wonderful place for a little kid to live, stay. It's clean, it's healthy. And the lawyers kind of were grilling this lady on the phone and says, well, he could have just cleaned it up because he knew you were coming. And she said, the reason I had to retire is I have severe allergies. Hey, I would have had to leave the place if that had not been regularly kept clean, because I'm extremely sensitive to cleaning, dust, anything else like that. And she said that's the way the guy kept it. So bottom line though is, I like to think I'm a good decision maker, a good judge. Framing can be a problem. And the other one we know is about egocentric is black robe disease. Next one. So there's a theory. Judges have been specifically trained to follow procedural rules designed to minimize the influence of irrelevant information, right? So are we really immune to heuristic errors? That's the question. So there's a study. This is what the study was. All the judges, and like 200 of them, are given a one-page fact sheet. The one-page fact sheet is a very egregious sexual harassment case. Really egregious. Okay? The instruction is read the one-page thing, assume it's a court trial, and write down the number you would award in damages. Okay? Next. So, half the judges, unbeknownst to them, were told in the middle of the fact situation that there had been a prior motion to dismiss the case because it wasn't $75,000 worth of damages, which would defeat federal court jurisdiction. Okay? It was denied. So it should make no difference, right? Wouldn't make any difference. A, it wasn't part of the problem, and B, it was denied, so it should make no difference. The judges who were told of the motion awarded $882,000, not told of the motion $1.25 million. Okay? So you got to be a little careful in thinking that you're such a good decision maker that you can put things out of your mind effectively. Next. You think I'm done? Wrong. Here's a big thing you got to deal with in high volume courts. The best time to appear before a judge, we all know, is right after breakfast or right after lunch, right? What actually happens is this. As the morning goes on, you're going to be susceptible to get compassion fatigue and become risk adverse. You're going to be much more likely to be doing small sampling. Okay? So I need to end up in a high volume court to be really cognizant of how I'm dealing with decision making. Now, I will tell you flat out, there's no chance ever in my life I will run a marathon. But in my whole life, if I added up all the times I've run, the distances, it's still not a marathon. But I know enough about marathons to this is, it's not a sprint, and the people who actually are able to do it are really cognizant about how they're pacing themselves. So, excuse me just 1 second. You got to be careful in high volume courts about compassion fatigue becoming risk adverse. There's a very good study out of Stanford that clearly shows we're highly susceptible to making different decisions on almost identical facts later in the morning, later in the afternoon. The way you deal with it is be cognizant of it. So cognizant meaning, would I have done this earlier? Or do I really need to take a break? Next. Emotion is a weird kind of thing because until recently, questions of emotion, subjective judicial emotional experiences, emotional display, were not part of the discussion about how or what the judiciary is about, and that's not true anymore. Go ahead. Mood is something we got to be aware of, right? So, those in a negative mood engage in more reflective, deliberate processing. Those in a positive mood are more likely to do reflexive, automatic processing. So it's a little bit counterintuitive. I'm in a really good mood, and all of a sudden, you look skeptical of this.
I am skeptical. I mean, it just seems surprising.
No, believe me, I thought it's true, but it is. What happens is this, and this is about judges. You're in a really good mood, you're going along like this, it's really easy to drift into reflexive stuff. Okay? You're stressed out and all this other stuff. I'm more careful. Okay? I'm not saying you shouldn't be careful. I'm just saying I need to end up knowing a lot about my individual decision making. It's also plausible that it doesn't apply to you. Right? So what I'm really trying to say is it's not likely it's not plausible to you, but if we could end up saying there are about 5 or 6 things that I need to be really good at in high volume courts. I need to be really good about being careful about anchoring. See, what happened in the example of the $75,000 was that the $75,000 anchored the judge's decision that this isn't worth that much money. And what can happen is this. Anchoring happens a lot in bail decisions. If the first thing that you hear is a recommendation from a prosecutor with a number, that number can be out there anchoring you. Because what you're actually ending up then doing, if you're not careful, is you're asking whether the number's reasonable, not whether the question of release or not is. And you just got to be cognizant of that. Okay. Multitasking. This is where, do you have a big screen on the TV and the computer that you got? Here's my suggestion. Go put a yellow Post-it on it that says, "Why are you looking at me?" See, when you start getting tired, you're losing focus and stuff like that, it's so easy to go look at the computer. I didn't need to go look at the thing. If it wasn't there, I would not have a thing. So you got to be cognizant of that. Next. So this is an example about multitasking and how we come across to people, and it's tough. This guy is a psychiatrist. These are judges, and the case that he's testifying in came from Norway, where 70 young boys were murdered by the defendant. No question, they've been murdered by the defendant. It was a big, huge, horrible thing. I mean, for a little country like Norway, is horrible for any country. So, you can't see it very well, but right here is Solitaire. He's playing Solitaire. So the press comes at the end of the day to the court administrator, I believe, so it would be you, and says, the judge was playing Solitaire during the testimony of the psychiatrist. So what do you do if you're confronted with that? This is what she said. That's an unauthorized photograph, and whoever took that is going to lose their credentials. You know what? That didn't work. Because the next day, this photo was in all the newspapers in Norway, some in Sweden, a lot in Finland, and this is the point. Nobody in the United States has seen, except judges who come to my stuff, has seen this photo. But if you were a judge in Norway today, you are extremely careful about how the computer comes across. So this is my tip. If you take handwritten notes in the courtroom, my suggestion is you begin the day by saying, I am really a copious note taker. Does that bother anybody if I take notes? You do that.
I don't tell them, I just do it, right?
But I'm not saying you shouldn't take notes. It's that conveys, I'm interested in what you're saying, and everybody's going to say no. If you like to type stuff, I like to type and take notes as I'm listening, and will that bother you? And everybody will say no. The lawyers will say, she says this every day, but the bottom line is it's not for them, it's for everybody in the audience. And so now we kind of got a thing on how to deal with multitasking. Okay. I'm stressed right now, so you got to figure out how to deal with stress in a very high volume thing. If you get the Google alerts for judicial ethics, you can actually put this in it. Every day it'll send you all kinds of stuff, and I get this stuff. And almost every day you'll find some judge who you think, what was he or she thinking? They do something insane. Okay? And I think, I'm sure that at some level they're weird. But some of it I think is they just haven't figured out how to deal with the stress of a high volume court. There are other places that deal with people who are difficult to deal with, who are really under stress, and they're pretty good at dealing with it. And I'll give you this example. Emergency room physicians and nurses in a major urban hospital have a lot of people coming in. They have people coming in being shot. They have people coming in with their kids choking. A lot of stuff like this. So a hospital in Los Angeles decided in the waiting room we're going to have somebody sit and play harp music. And they said, that's kind of hokey. Except it turned out it really made a difference. It calmed people down. Now, I'm not suggesting that the courts of Georgia should go out and hire harp players. Okay? But this is what I think the point is. They thought about, how do I get people who are in stressful situations calm and relaxed as we possibly can given the circumstances? Okay? So even if you ended up saying, well, there's some doctor in Georgia who has spent some time thinking about how do we deal with stress of doctors in those urban courts and stuff. And he's going to come and have lunch with you and explain, this is what we think about with doctors in trying to deal with this. How do you deal with hopelessness? This is, if you look at one of the things that happens with compassion fatigue is you begin to think this is hopeless, this is just, and now you get rude and all kinds of other stuff. There are doctors who work on a children's oncology ward in which most of the kids die, and yet they're emotionally prepared to deal with it. They're emotionally prepared to end up saying, I won't accept death. I'm going to keep fighting it. And then at some point I'm going to end up saying, well, that's all I can do. Okay, next. So black robe disease, I mentioned this before, it's fatal. There is no known cure. If you don't think you can get it, you're practicing unsafe judging. Okay? So we got to kind of think about how do I, now the difficulty I think is you're already a judge and you haven't started out with a plan to prevent it. So I got to try to figure out how to make sure that if I got it, could I overcome it? Okay? And that really means you got to try to figure out a way to get feedback. Okay? So when I did this study about did people understand the order, people got feedback. Okay? You don't have to do it all the time. You could easily end up saying in your court, we're going to do a study to determine whether or not people understood what was going on. So I did a more recent study in Hennepin a little less than 2 years ago. If you want, I'll give you the instrument. It's pretty easy. You go make sure that people are asked before you leave if you'd fill out the little instrument. Then you get somebody to correlate what the stuff is. You tend in those things, frankly, to be better than you think. Because the people who are really mad at you don't fill out the survey. But you can learn some things from it. Okay, black robe disease next. It took me a long time to learn to never get mad, just get sensibly irritated. Right? So we do not need mad judges. Sensibly irritated you can be. Next. There's a really good professor, she's a really smart woman, Professor Terry Maroney, who spends a lot of time dealing with judges and emotion. Go ahead, next. Judges perform emotional labor. Go next. There we go, just come. Go back. So a lot of what we have to do in high volume courts is to really sit down and say, I need to know how to manage other people's emotions. I need to get really good at unhappy witnesses, defendants, jurors, spectators, family members, feuding lawyers, cranky clerks, the whole 9 yards. Okay? Now, one of the strategies on that level can be humor, but you have to be careful about it. Okay? So you don't want to make fun of somebody, but how many of you really get upset if you have feuding lawyers who just start fighting with each other? Everybody doesn't like that one, right? So what I tend to do is to say, counsel, I know you're a good lawyer, but I really don't think you're going to convince her. I think she's hopeless. So maybe you try me, and we'll just, but it's said in a tone to kind of lighten people up. Okay? So I need to figure out, I need to over time in my career say, I've added things to my arsenal. I know what these things are. I know how to deal with that. And I've asked other colleagues and stuff, okay, what's the best way to deal with a feuding lawyer? Or, since you weren't here, a crying person. Person who's all of a sudden really crying and stuff. How do I get that? The person who wants to talk far more than we have the time for right now. What you say is a lot more complex than I'm really prepared for right now, but I have a suggestion. How about if you sit down there, I can deal with some easier cases, and then we'll come back and we'll get you. Okay? So, because I've tried this law of Georgia doesn't let me consider that, and I'm going to have some problems with you. So how about if I try to get you over someplace else, and then I'm going to move some other people through. And the other thing that can happen with that is by the time I get to you, you're now calmed down a bit. And then you got to handle your own emotions. Okay, next. Do you have the ability to go on the internet there? Okay. I want you to go on the internet and find the monkey business illusion. Have you seen that? Okay, go down to this deck and play that. Okay, everybody, watch.
The monkey business illusion. Count how many times the players wearing white pass the ball. The correct answer is 16 passes. Did you spot the gorilla? For people who haven't seen or heard about a video like this before, about half missed the gorilla. If you knew about the gorilla, you probably saw it. But did you notice the curtain changing color or the player on the black team leaving the game? Let's rewind and watch it again. Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected events. And that's the monkey business illusion. Learn more about this illusion and the original gorilla experiment at the...
So, how many of you saw the person leaving? You saw it, but have you seen it? You saw it?
Well, I noticed that there was, I didn't actually see the person leaving, but I did notice there was one less like person.
Okay, that's pretty good. See, the reason I showed that is I got you all set up. You had nothing to deal with. You didn't feel the pressure of I got to do something really fast. I got to get through a big calendar and stuff like this. You were singularly focused on that thing, and some of you didn't see all the stuff. Partially because it's set up that all you had to do was count the 16 passes, or the number of passes. But that's the problem about framing stuff. You come on the bench, I know what this case is about, bang, I get in trouble. Okay? So you gotta end up saying that if I'm gonna be really good at dealing at high volume stuff, I need to be really good at understanding about framing, anchoring, how I make decisions, and to be pretty attentive to that. See, when I said put a post-it on your computer, some of you thought that's stupid. We need the computers. But none of you would have seen that whole thing if you'd been looking at the computer when that happened. I'm not saying we should be troglodytes and not anti-tech stuff. I'm saying that you got to kind of deal with that kind of stuff. Okay, so last thing, if you're in a big high volume court and you can't take a recess, stop. Meditation might work for stress. Stop what you're currently doing, take a deep breath and focus on the sensation of breathing. Observe what you're thinking and feeling and doing, and proceed now with a new awareness. So I got to really understand high volume stuff, and you can do it with nobody will know what she's doing, nobody will know what he's doing. But I need to know how to deal with that, because the goal here is I want to get through this calendar, and I want to do it in a way that I don't have people burned as a result. Next. So, bottom line about procedural fairness in a nutshell: was the person listened to, or the litigants treated with respect? Do they understand what the decision was and why the decision was made? Next. You could do this in your courts. So, do you remember in 2010, 3 Supreme Court justices in Iowa got defeated? It was a big thing. They issued an opinion that said gay marriage was protected by the Iowa Constitution. Newt Gingrich, guy from Georgia here, Newt was going to run for president. He put a boatload of money into Iowa to defeat these 3 justices because of the gay marriage decision. I am then invited down to Iowa 10 times to meet with the judiciary in the aftermath of that to try to figure out how to deal with this. And so I ended up at one point saying you need to change that in politics. If you got a losing thing, which was judicial independence, that's what they really ran on. You change the subject. So my suggestion is you change the subject and create a litigant's bill of rights. So I'm talking with the Chief Justice of Alaska and telling her that story. She said, "Oh, that's brilliant. We're going to do it in Alaska." So this is what's in every single courthouse in Alaska in 6 different languages. And it says, the fundamental mission of the Alaska court system is to provide a fair and impartial forum for the resolution of disputes according to the rule of law. Fairness includes the opportunity to be heard, the chance to have the court process explained, and the right to be treated with respect. The judges and staff of the Alaska court system therefore make the following pledge to each litigant, defendant, victim, witness, juror, and person involved in the court proceeding. We will listen to you. We will respond to your questions about court procedure. We will treat you with respect. So what you can do is take out the Alaska seal. You put in Georgia, right? You take out Alaska, you put in Georgia. And there you're all set. And if you need it translated, call the people in Alaska. So this is the website that we have, proceduralfairness.org. Next. Steps I would take if I were you. I would try to do a couple of studies, or I would try to videotape and say, okay, I want to try to find out, are people... You see, the other thing about the high volume stuff is we're not good at explaining to funders what the effect of high volume, lots of people in the courtroom are. What we have tended to do is to end up saying, we're working too hard. Okay, that's not going anywhere. Because the guy who's cleaning the windows in the state capitol, he's working too hard, the teachers are working too hard, everybody's working too hard. If you ended up saying that the litigants, your constituents, are not being given the time they need to explain their case, now we change the thing. It's not about me. I can get through the calendar. It's about your constituents. So we looked at, for example, how much time an average small claims court person would have. And then you say, you know, it's not much. It's only 15 grand. And we'll give you 2 minutes to make your case. Oh, wait a minute. That doesn't sound very good. And then the next one I do think really is just about the video. It really helps you look at how I come across. If you actually do, you don't need a very sophisticated camera. That one I do. And if you go out and you say, you may notice that we're filming me. The reason we're filming me is we're trying in our court to figure out how we can become better judges for you. Don't worry about the camera. And then nobody remembers the camera. Okay? So if you want to call me at any point, that's my phone number. There's my website. Very good, and I'll go out there and convince the others who weren't here. Thank you very much for having me.
Thank you. Thank you very much, Ella, speaking. Thank you very much for joining us this afternoon and for using all day, because I think you flew in early this morning, and we're going to hold you until this afternoon when you can fly back out. So thank you very much. We do have a gift, as you will. Open. You enjoyed it. I think this presentation was supposed to last until 2:30. It is now a little bit after. It's actually almost 3. So I am not going to hold you all much longer. Actually, I'm not going to hold you all at all. I would encourage you to grab something to eat on your way out and enjoy your weekend. Thank you all for coming.